you've collected from people to just throw on that
fuck?
literally have nothing to do with any of this.
Uh-oh, Skinwalker.
Like, I don't even know what I can respond to for these. Like, it's not even the subject matter here.
Don't know. I don't think, no.
Defendant's attempts to ignore or downplay the harm he is causing falls flat in the face of the overwhelming evidence presented. Defendant declared the following about two potential witnesses.
Dude, what is going on?
That's why people like Jessica and Queeman, if I could put their fucking balls in a vice and crush them and then feed it to them and then slice their dick off and kill them. See blank at minute 56.
That is such a base statement. You have no idea.
That's why people like Jessica and Queeman, if I could put their fucking balls in a vice and crush them and then feed it to them and then slice their dick off and kill them. See blank at minute 56.
Yeah, guys, he totally meant it literally. He totally meant it literally, guys.
42.
Oh my god, it's so funny.
When did I even do this interview? I feel like this interview was done in like January or February. Does Willie say? 1, this interview was done a long time ago. 2, this isn't even published on my channel. 3, these people are not parties to this case. These people are not witnesses. They have nothing to do with any of this. And none of my commentary about them in here has anything to do with this case. So it's like, it's so fucking stupid.
It's definitely serious, true. So true, Queen, King.
This commentary is not merely uncomfortable or critical,
Duke Nugs,
as defendant absurdly claims, but rather violent and extremely prejudicial. This commentary undeniably deters witness cooperation and undermines the fair administration of justice. Both of these people, Queeman and Gisticle, have talked about me incessantly for months after. Clearly, they're not deterred, and clearly, they're not afraid. So, like, what are we even talking about here?
Yep, they're not afraid.
Like, these people talk about me almost daily.
Bro lives in Britland. How does Destiny even touch him? How does Destiny even touch him?
In another of defendant's income-producing streams, I love how they say that, he recently accused the plaintiff and her counsel of fabricating evidence. I love also how we're being honest now. Thank you. We're just taking straight rips from Kiwi Farms. https://uploads.kiwifarms.st data/video/ also their links are broken half the time, so I don't even know. I'm sure the judge will figure it out. Like, actually fucking clown show that they're literally just control F5ing my Kiwi Farms thread every day for their next legal argument, but that's cool to just waste my time and destroy my life.
Scared of Destiny all of a sudden? That is really funny, actually.
Thank God my prior circle of friends is respectful enough, though, to not make any commentary about this at all on the other side of it, but only on mine. Very spine-possessing people. Defendant tells his hundreds of thousands of followers, I bet this is a fake message, and clearly, opposing counsel and plaintiff are dumb enough to fake this in the stupidest way possible. Oh, is that about the declaration that I'd already read? I think it is a fake message. I don't believe it.
Yeah.
I don't believe it. And I'll say it again. Put me in your next filing. Defendant has failed to refute the overwhelming evidence consisting of his vitriolic and threatening public commentary, its impact on witness participation, and its actual and ongoing harm to these proceedings. To allow defendant to continue with his unfettered public commentary will jeopardize the integrity of these proceedings and impair plaintiff's right to present witnesses. Saying all of this while even temporarily sealing the transcript where we spoke in front of a fucking judge is the ultimate in cuckoldry, in spineless weaponization of the legal system, and in weaponizing the white woman status to seal the transcript where we're both under oath. And we have to answer honestly in front of a fucking judge. And it's not just the unhinged, deranged, and incoherent rambling.
Why does he talk about this on stream? Because Queeman and J-Stock has been talking about this on stream, so he's like trying to counter their narrative, basically. That's what's happening.
Things of a schizo lunatic that can apply to either plaintiff or her counsel. Like, it's actually it's subhuman behavior. Like,
yeah, he's guard countering. Yes, he's guard countering, okay? Guardian. Yep, that's right.
The protective order is the least restrictive means. Defendants contends that voir dire, I don't know what that means, good job.
voir dire,
Voir dire.
Voir dire.
A preliminary examination of a witness or a juror by a judge or counsel. Wait, wasn't this a public hearing? How can they make it private? It was public. I don't think they can make it private. Hopefully the judge should rule against that, but we have to wait for the judge to rule on it.
I thought it was just
Finnegan has
content. It is content, technically,
Voir dire. That's what he said, right?
if you must.
voir dire,
Voir dire. Content said, voir dire. Jury instructions or confidentiality orders are sufficient alternatives. They are not. This
Not
case
the
is still in the
main reason, sure.
pre-trial phase, and voir dire does nothing to address ongoing harm to witnesses, witness intimidation, and or the risk of future disclosures of confidential material. The proposed order is narrowly drawn, addresses only the harmful conduct already documented, and preserves all rights to file pleadings and argue the case in court. Moreover, although protective orders governing discovery are standard in cases such as the instant one involving sensitive personal information, not only did defendant refuse to cooperate with plaintiff's efforts towards a stipulated confidentiality agreement, but he has actually opposed plaintiff's motion for a protective order governing discovery. And although that protective order would serve to protect confidential, sensitive information of the parties, it would not prevent the defendant from continuing his public doxing and threatening and false commentary.
Oh, doxing. I mean, is it public doxing to call him Stephen Benelli II with Destiny, and then having JSTLK and Queenman review it?
Defendant contends that the proposed protective order would somehow restrict or impact his right to defend himself. The narrowly tailored order does no such thing unless his right to defense involves attacking and threatening plaintiff, witnesses, and counsel. It does not. The First Amendment does not protect speech that interferes with the fair administration of justice. The fair administration of justice, my God. Defendant's attempts to construe plaintiff's motion as nothing more than an attempt to restrict public access to this court is nonsensical. The pleadings are available to the public, and nothing in the proposed order seeks to alter public access. That's literally what a seal does, or unless they're talking about that's what a protective order. If they're filing to protect names and stuff, that's literally what it does, is to keep stuff off the public record. But okay. Say the judge sees through this bullshit. Is it possible for the plaintiff to be forced to do like a full public retraction or something? No, they would never. I would have to like counter seal or something like that, or counter sue or something. But the applicable precedent supports the entry of the narrowly tailored proposed protective order. Defendant fails to distinguish the controlling precedent relied on by plaintiff in her motion. Indeed, the opposition fails to even address or attempt to distinguish the primary case relied on by plaintiff Hernandez, in which the Southern District of Florida imposed restrictions on trial participant speech after finding likelihood of prejudice and no less restrictive means. Defendant's opposition fails to address the critical distinction between constitution-protected commentary and targeted speech that threatens the integrity of judicial proceedings. Do you get the vibe that Doe's lawyer hates you personally because she's seen all your negative comments? I think they do because it's a personal friend. That's what I'm pretty sure it's a personal family
That's
friend.
so cocked, dude.
Particularly through the intimidation or silencing of witnesses, restrictions on extrajudicial statements by trial participants are both lawful and necessary. The evidence submitted showing the defendant has publicly threatened, disparaged, and attempted to dox potential, specifically identifiable witnesses demonstrates precisely the kind of conduct these authorities contemplate. The Southern District of Florida recognized in Hernandez, when witness participation is chilled by public attacks, courts may impose narrowly tailored speech restrictions as the least restrictive means of safeguarding the proceedings. This motion does not seek to silence one party or prevent any valid defense. It is about protecting vulnerable witnesses from intimidation and ensuring that testimony may proceed fear or retaliation. Defendant misleadingly claims that this is a low-profile civil dispute. Opposing thing, page 11. It is not. I wonder what this was in the context of. I mean, it's a civil case. It's not like a huge corporate litigation thing, and it's not a criminal case. But there have been numerous press releases and articles about it, and hundreds of thousands of people tune into defendant's streaming platforms to hear his distorted version of the proceedings and allegations. As I just read the court documents, but okay. And to listen to and encourage with financial remuneration his abuse of the plaintiff, her witnesses, and her counsel. They keep bringing this up over and over and over again. Despite the fact that I've lost money on this. And they know that too, because that was also part of the hearing, which is probably another reason why they want to keep it sealed.
and must be destroyed for justice.
I think this woman could have had law school paid for, but went this route instead.
Deplorable.
I think she already took the LSAT one, so she
Evil.
probably took it and got like
Horrific.
a fucking 70 on it, and was like, "Fuck me, we'll just play lawyer instead."
Vanquished. It was vanquished?
This is not the run-of-the-mill
well
civil
done.
dispute, but rather a high-profile dispute with lurid content and a trial participant, the defendant, who has his own streaming platforms with almost 1 million followers. This scenario only exacerbates the high risk of prejudice to these proceedings due to defendants' threatening, harassing, and false commentary.
Bro, I'm so sleepy. It's bedtime, dude. It's totally fucking.
Plaintiff's limited
I did
public
not
comments
get
do
no
not
sleep.
warrant denial
It's so
of the
hot.
order. Defendant argues that plaintiff's own public statements undermine her request.
Fucking dirty.
This is
How?
false equivalence. Plaintiff's
What?
posts consist of announcements of procedural
How?
rulings. For example, sealing of witness identities, a fundraising effort. Defendant should certainly not object to plaintiff's GoFundMe page. It's a Give Send Go page. Got him. Since he has been profiting immensely from this case by streaming on a
Skill
regular
level.
basis about it.
Skill level.
My lawyer's fees are up to about $200,000
I'm just a
so
skilled
far. I have not
person.
made that much money
Oh shit.
talking about this case. Not to mention canceled shows, reputational harm that will likely
Yep.
never go away, and everything else involved in this.
Yep.
But
True.
that's cute
is
to
true.
say this over and over again. They really, really, really like to run with this argument.
True.
This profit revenue is evidenced by the number of views on his videos about the case and the number of comments and questions. For example, streamers such as Defendant receive revenue from their YouTube channels based on memberships, AdSense revenue. Streamer gets paid based on number of users viewing ads, and super chats. The user pays to have his or her message highlighted in the live chat during a stream. The more money is paid, the more likely the streamer will read the message aloud or
Like, what do you expect? Like, do you want him to be held liable to every single super chat or dono that he gets while reading the lawsuit? So he makes less than 200,000 of what he spent so far, right? And you want him to what, like, give you all that money to turn off super chats when he's addressing the lawsuit? Like, these just seem entirely unreasonable, no?
respond to the question. A fundraising effort in general calls for information relevant to her case or witnesses. Again, I'm sorry, little bro, but if you want to be a big boy or big girl and you want to be an adult and you want to file a court case, then you should file the case with your affidavits and everything in hand. If you're filing a case with nothing on pure fucking lies and copium, which is what she's done, and she knows that she's done that, and then you're praying to God that after attacking my reputation as hard as you can, after going after everything I have as hard as you can, praying that somebody comes forward to substantiate your bullshit case, that's on you for being a fucking retard. Sorry. CCF 992 to 95. In stark contrast to the defendant, none of plaintiff's posts.
Destiny is so sassy. Excuse me, after all of that, it's on you for being like a retard, alright? Look, I'm just saying Destiny would make for a good mean girl, okay? He is California coded. Right.
Involve threats, harassment, vilification, saying that lying about her age over and over again, saying that she was 19, saying that I
Excuse me?
purposefully wanted my sexual content to be leaked and spread all over the fucking internet. All of that, none of that was vilification? Seriously? Exposure of sealed identity, and again, it wasn't sealed yet, it was the same day. Or publication of confidential materials. I don't know what they're even referring to there. Plaintiff has not doxed, intimidated, or mocked any party or witness. There is no evidence that plaintiff's limited posts have deterred witness participation or jeopardized trial fairness, while there is ample evidence that defendant's posts have done so. See above. Further declarations of people that aren't even relevant to this case based.
Hooray, Ambi.
Defendant distorts the request for relief by arguing that the post protective order would allow plaintiff to broadcast her message while silencing position, but it is patently clear that the request for relief would apply equally to both plaintiff and defendant and seeks only to silence threatening, harassing, and false commentary. See ECF 84.5. I forget. Did their thing allow them for her to keep her stupid fucking GoFundMe up? Her Give Send Go up? Is it just me, or does this feel like it hinges entirely on the premise that you leaked everything to Kiwi Farms intentionally, despite you being the one most directly? Yes, it does. I think that's one of the overarching narratives that kind of got destroyed at the hearing, which I think is one of the reasons why, another one of the reasons why they wanted that transcript sealed. And it was funny, this is one of the things that I was like happy about, is I could see because the judge kept asking questions where he's like, wait, so he published.
Bro, you know what I'm gonna do after this? I'm gonna go and I'm gonna see what JStock has to say. Okay? I'm gonna see what JStock has to say. Destiny crying about leaking stuff is hilarious. Oh no, totally. Destiny's gonna get obliterated in this lawsuit, yo. He's gonna get obliviated, okay? Like he said.
Published that to Kiwi Farms, and then she'd be like, well, no, someone else. And it's like, oh, okay. Or when she was talking about, when I found out that she'd sent all of our videos to her ex, and the judge was like, wait, he sent all of your guys' videos to your ex-boyfriend? And then she's like, no, I sent our videos to my ex. I was like, oh. Like he was, like I could see the lights turning on the judge, and he was like, wait, what? Or like, wait, really? But hopefully we can read the transcript soon. Prohibited content.
He's using the leaf blower again. Why?
That harasses, threatens, or intimidates the parties, or publicizes or repeats any sensitive personal allegations or private details underlying the claims. Publicizes or repeats any confidential settlement discussions or communications. Which are protected under Federal Rules of Procedure 408. You're gonna have, wait, is this even real? Protective order, and part of it is misrepresents or mischaracterizes the content of legal filings. What?
It's fine, the leaf blower, I mean? You sure? Okay. I'll take the word for it.
Rule 408, compromise offers and negotiations. Prohibited uses. Evidence of the following is not admissible on behalf of either party, of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or condition. Furnishing, promising, or offering, or accepting, promising, offer, a valuable consideration and compromising or attempting to compromise the claim, and conduct or a statement made during compromise negotiations about the claim, except when offered in a criminal exception. This is court. Wait, what?
What?
I'm sorry, am I not understanding this? This Federal Rule of Civil Procedure, it sounds like it has to do with whether or not, like, things that you say during negotiations for, like, a settlement are admissible as evidence towards the validity of the claim or whatever. This doesn't sound like it has anything to do with protecting communications. Am I looking up the correct... Federal Rules of Civil Procedure 408. Compromise offers and... Okay, I'll just keep reading. I'm sorry. As a matter of general agreement, evidence of an offer to compromise a claim is not receivable in evidence as an admission of, as the case may be, okay, yeah, this makes sense. So, like, for instance, if this makes sense. Let's say that I'm like, okay, fuck it. Let's settle. Let's have a discussion, right? We've had discussions on settlement. Oh, I'm leaking more information. Let's say that I was to say, okay, fine, I'm going to settle. I'll give you X dollars, we make a statement or whatever, and then that's fine, right? And you're like, and then they're like, no. And then let's say that, like, later on in the case they file, and by the way, I know that he's guilty of this because when we were having discussions of settlement, he offered me X amount of dollars, right? That's what it sounds like Rule 408 is governing. Not like evidence, like you.
Shops having an American flag in the background is the most unadulterated base thing I've seen. Base shops? Yes, right. So, again, it's a... I don't want to say, like, solidarity with the anti-Trump protesters. But close enough, okay? If I'm going to be spouting anti-Trump rhetoric and, like, liberal rhetoric and stuff like that, I better have an American flag in the background. It just looks good, okay? It's really as simple as that.
You can't submit evidence to prove or disprove the validity or amount of a disputed claim based on the settlement discussions. As with evidence
appealing
of
to
subsequent
Latinos.
remedial measures dealt with in Rule 407, exclusion may be based on two grounds. One,
But
the
the
evidence
plush,
is irrelevant
though?
since the offer may be motivated
I
by
don't
a
know what
desire
you're
for
talking
peace rather
about.
than from any concession of weakness position. Validity was 2, a more consistently impressive ground is promotion of the public policy favoring the compromise and settlement of disputes, while the rules are ordinarily phrased in terms of offers or compromise. I'm sorry. Okay, this is why I don't. Reading their
The
citations.
plushie is cute. What are you talking about?
I don't know
it's a
why
cute
this was
plushie. It objectively
cited here.
is.
Sorry, 20 euros. Mandami has
You're
said that he
crazy.
wants the city to run supermarkets. Do you agree that it's idiotic? The profit that capitalists make on supermarket products is already low thanks to capitalism, so it will not bring down prices.
Everix.
I mean, yeah, personally, I think it's a dumb
How do
thing,
I
but
even
mean,
say
we'll
your
see what
name?
happens, but
Everwix? Everwix? I don't like that shade of blue. Well, I don't like the shade of your mom's ass. Okay.
hold on. Just make sure I'm looking at the correct. Yeah, I am. Okay. This is. Remember that they described this order as incredibly narrowly tailored. So they're saying this is a narrowly tailored order. And the order is, no person covered by this order shall make or cause to be made any public statement, including on live streams, podcasts, social media platforms, blogs, or to the press that disparages,
your mom's ass is
harasses,
perfect. Dude,
threatens, or
Oh, no.
intimidates the parties, witnesses, potential witnesses, or either party's counsel. Oh, okay. What does that even mean? What is a potential witness? Like somebody named in the like pre-trial disclosures?
Jay Stelk.
Publicizes or repeats.
I mean, think about it. Think about it. On the night of the crime, okay? On the night of the crime, when Cherry was being recorded by Destiny, okay? When that was happening and sex was being recorded, are we sure that there isn't a third person in the room? All right? I want you to think about this, okay? Queeman is skinny. He is extremely thin. He can fit not just inside of closets, okay, but behind closets, okay? Can we be sure that these two people aren't the only people in the room at the time? We can't be sure, okay? Which is why I would like to propose the idea that Queeman has been hiding under the bed the entire time that they've been fucking, okay? As the bed had been squeaking, as the bed was squeaking due to Destiny's 15-2 pumps, okay? His powerful 15-2 pumps, all right? As it was squeaking, Queeman was below taking notes, okay? Listen, he is a dedicated A-logger, okay? Due to his history as an A-logger, we can reasonably conclude that he lives inside of Destiny's walls, okay? So, yeah, all right.
Any sensitive personal allegations or private details underlying the claims of this action. What does that even mean? I can't even talk about the subject matter of the court case? Like, publicizes or repeats any confidential settlement discussions or communications which are protected, they're not protected by this, or any meet and confer communication with counsel. What, so I can't bring up the fact that she was, what,
15-2.
threatening to kill herself if I didn't pay her off? Or that they were asking for $15 million from me initially?